Good morning. My name is Jonathan Bonnitcha, and this presentation is based on material from my new book, Substantive Protection under Investment Treaties, a Legal and Economic Analysis. And in particular, this presentation focuses on the economic implications of the investment protection provisions of investment treaties. So by investment protection provisions, I mean provisions like expropriation, inequitable treatment, post-establishment national treatment. These are core provisions of investment treaties which normally allow a foreign investor to bring a claim against a host state to investor-state arbitration and claim for compensation if they've been breached. The economics of investment treaties is something that has got relatively little attention up till now, but I hope I can show in this presentation how a more precise look at the economic problem that investment treaties are supposedly designed to solve can help inform debates about whether governments should be signing investment treaties at all, and also, if so, what sorts of provisions should be included in them. So I'm going to look at three potential problems investment treaties could be designed to solve, and the first of these is discrimination against foreign investors. And this is an obvious place to start because principles of non-discrimination, the need to provide a level playing field, are common across several areas of international economic law, including trade law, competition law, thoughts about government procurement, state aids, and they also play a central role in policy debates about investment treaties. So, for example, in discussions about the Transatlantic Trade and Investment Partnership, we've heard the claim that foreign investors are vulnerable to discrimination in the host states in which they operate, and therefore investment treaties are important to provide a level playing field. The basic economic rationale here is pretty simple. So, discrimination means that the most productive firms won't necessarily undertake investment projects. Instead, less productive firms that benefit from more preferential legal or regulatory treatment will undertake the projects because of the advantages they receive, and the result leaves everyone worse off. So that's the supposed problem. But the first question is whether this is actually a problem that foreign investors suffer from in practice. And here, the evidence is more mixed than people seem to think. So it's true that in some countries, foreign investors do suffer from restrictive regulatory treatment and from barriers to operation that do not apply equally to their domestic competitors. At the same time, there's also evidence from cross-country studies that foreign investors tend to do rather well from investment incentives, and in some cases, they get more generous treatment from incentive regime than their domestic counterparts. Also, scholars have looked at the regulatory influence of foreign firms and found that they have at least as much ability to influence regulatory policy in the host states that they operate in when compared to their domestic competitors. So there's a question there in the first place of whether discrimination is actually a problem in practice. But let's assume, at least in some countries, that discrimination against foreign investors is a problem and that we wanted to try and solve that problem in an investment treaty. Well, the treaty would need national treatment provisions to redress substantive discrimination. So that would guarantee equal legal and policy treatment to foreign investors regardless of nationality. And then if foreign investors also suffered from discrimination in the courts of host states, there could be an argument for investor-state arbitration, so to provide an alternative forum to foreign investors for claims, even if that's not available to their domestic competitors. But these are relatively limited justifications of what's in investment treaties as we find them now, because investment treaties go much further than simply trying to redress the issue of discrimination. So what other problems could investment treaties be designed to solve? Well, the second possibility is a hold-up problem, represented here in quite simplified form in a two-stage diagram. So in the first stage of the game, the investor decides whether or not to make an investment. And in the second stage of the game, if the investor has decided to make an investment, the host state decides whether or not to expropriate that investment. And the payoffs have been assigned, so the investment involves a sunk cost of $50 and a potential surplus of $100, which the host state and the investor have agreed to share equally. So the hold-up problem is that if there is no investment treaty, it's rational for the host state to expropriate the investment after the sunk costs have been incurred. So an example of this would be a large mine. The investor spends billions of dollars to build the mine. When that's ready to come on stream and begin generating revenue, the government steps in, seizes the mine, and takes the benefit of the project for itself. And the hold-up problem is that the investor knows that the rational move for the state at the second stage of the game is to expropriate the investment. Because the investor knows this, it decides not to invest at all at the first stage of the game. The result being that mutually beneficial projects don't go ahead, and both the investor and the host state are worse off than if the investor had gone ahead as originally planned. So the role of an investment treaty here is to solve that problem by guaranteeing compensation would be paid in the event of an expropriation. But how prevalent are hold-up problems really in practice? There are several reasons to think that they're much less common than the simplified model we just looked at would suggest. One reason why that's the case is because host states are subject to other constraints, so constraints from their own law and legal systems, and potentially from internationalized contracts they enter into with investors. A second reason is reputation effects. So the host state knows that if it does decide to expropriate one investor, then that will jeopardize future investment and current investment from other investors. So it's not necessarily rational for a host state thinking about its reputation to expropriate investments even in the absence of a treaty. And then the third reason why hold-up problems might be less endemic than the simplified model suggests is because many industries don't involve such serious sunk costs as the sort of classic hold-up example of a mine or offshore oil and gas, and that there are also possibilities in project structuring to reduce the amount of sunk costs that are incurred in early stages of investment, and that minimizes also the risk of hold-up problems. So hold-up problems may be an issue in some states, in some industries, but might not be in others. But let's assume that we're talking about countries where investors do suffer from hold-up problems. What would an investment treaty what would an investment treaty need to do to be able to address those? Well, the focus would need to be on legal rules that are about protecting the investor from that sort of opportunism by the host state. So the situation where the host state steps in and tries to appropriate a greater share of project benefits. And that's actually something that's quite different to the way that a lot of existing provisions of investment treaties, particularly jurisprudence under the fair and equitable treatment provision, is geared. So existing jurisprudence is much more focused on questions about protecting the investor from loss. Whereas if we were concerned about solving hold-up problems, we would be looking more at situations where the host state is appropriating the benefits of the project. So a third problem that investment treaties might potentially be meant to solve is fiscal illusion. Fiscal illusion, the basic problem is that when it's making regulatory decisions, the government ignores the impact of its regulatory measures on foreign investors, and this leads the government to overregulate. And we have here on the slide a simplified model of fiscal illusion, again a two-stage game. In the first stage of the game, the investor decides whether or not to invest. And then in the second stage of the game, the host government decides whether or not to shut the project down, to shut the investment in light of external negative impacts of the project. So there's two important differences here to the hold-up problem. The first one is that here in the case of fiscal illusion, we have the government learning at the second stage of the game about the external negative impacts of a project, so for example, environmental pollution. And the second difference to the hold-up problem is that if the government chooses to shut the project down, it's not able to retain any of the residual benefits of the project. So this is not a case where the government is trying to seize an asset to operate it by itself. So this is all a bit abstract and complicated, but let's try and think of an example. So if we're looking at a case like TechMed in Mexico, you've got a hazardous waste facility that's been built on the outskirts of an urban area, and over time the urban area expands and people come to be living very close up against the boundaries of the hazardous waste facility, and there's risks of pollution and adverse health impacts. So here, the problem of fiscal illusion would be if the government decides to shut down the facility because the negative impacts affect the population, but without taking into account the impact of the decision to shut the project down on the investor. So mathematically, this would be a case of over-regulation. The government would over-regulate if the value of E is greater than 50, but less than 100. So in theory, investment treaties could solve these sort of problems. In practice, things are a little bit more difficult, and this is something that's dealt with in much more detail in the book. But I want to briefly try and explain why I don't think it would be possible for investment treaties to address these problems, even if they exist in practice. The first reason is that the model of fiscal illusion and the ability of investment treaties to solve that problem is highly sensitive to variations in assumptions about the way that government makes decisions. And what we saw in the previous slide is not necessarily an accurate model of government decision making. The second problem, or the second risk, is that in trying to solve problems of fiscal illusion, government risks causing overinvestment and regulatory chill through an investment treaty. Let's look at the slide again. So if the investor invests when an investment treaty is in place, you'll see that the payoff for the investor is positive regardless of how high the negative external impact of the project is. So that would be a case like TechMed, for example, where the investor knew that when it undertook the project, that it was likely to have very severe adverse environmental impacts, so severe that they outweighed all the economic benefits of the project. But if the investor knew that it would be entitled to compensation if the host state decided to shut the project down in future, the rational investor would go ahead with that investment regardless of the scale of the negative external impacts. Also, we can see that if there is an investment treaty, there's a risk of regulatory chill because the government knows that the payoff you'll see if it shuts a project down when there is an investment treaty in place is -100. So that might dissuade government from making the decision to shut the project down, even when the external environmental impacts justify it doing so. And finally, and this is a crucial difference between problem of fiscal illusion and hold-up problems, even if investment treaties are able to address this sort of over-regulation due to fiscal illusion, doing so is not something that has any benefit for a host state. All the benefit of dealing with that problem accrues to the investor. So there are difficult distributive issues there, particularly when host countries are negotiating with home countries in investment relationships that are primarily one way. So where does this leave us overall? Briefly, in theory, there are two problems that I think investment treaties could solve: hold-up problems and discrimination. But important questions for any investment treaty are about whether those problems actually exist in practice between the states in question. If those problems don't exist, there's little economic justification for an investment treaty. Where those problems do exist, there are economic justifications for an investment treaty, but that treaty perhaps should look different and be less protective than the sorts of treaties that exist now. And then I think this also has wider implications for how we think about academic debate about investment treaties. So often something you hear in discussions is that investment treaties need to be more balanced. So there needs to be a better balance between the economic rights of investors and the regulatory prerogatives of the state. But actually that sort of framing, seeing things in terms of balance, assumes that there is a clear and coherent rationale in the first place for protecting the economic rights of investors. And I think what I've tried to show here is that in many cases there is not a clear economic rationale for protecting investors' interests. This is only something that is justified when those two problems, hold up and discrimination, exist.